The Supreme Court has served notice it has the power to dismiss an election petition should its orders be disobeyed. The caution follows an explanation by counsel for the petitioner, Tony Letha, that they had opted not to file witness statements as ordered by the court due to pending applications earlier filed. According to him, Mr. Mahama has filed a stay of proceedings along with a request that the court takes a second look at its decision not to allow EC chairperson Jean Mensah to answer some questions. This is the latest in the case filed by the former President John Mahama challenging the results of the 2020 elections. Here are excerpts of what transpired in court today.
So hearing commenced first with the Justice of the Supreme Court asking whether its orders to the lawyers in the case had been complied with. Mr. Letha informed the court that his side had failed to file the witness statement, and this was an issue of concern to the panel.
Look, since then we have filed an application for stay of proceedings, which is scheduled to be heard today. So our understanding
of application for stay of proceedings is that you don't file the processes ordered by the court because you have filed an application for stay of proceedings.
My Lord, in fact, the application is actually intended to hold matters. That's our understanding. Pending the... I beg your pardon, my Lord.
Then you don't even have to sit.
My Lord, I didn't...
That is what your understanding of the stay of proceedings. Then you don't even have to sit as a court.
The Supreme Court is a very busy place. The Supreme Court is not a forum for organized, rehearsed, and choreographed theatricals or melodrama. It's a place for real, hard, and serious legal work. It's not for flurry of literature, long prose, and rather dull English, devoid of any legal merit. I want to advise my colleagues on the other side that if it ain't broken, don't attempt to fix it. We are ready for them on Thursday.
The language that he employed this morning is unacceptable in describing the actions of petitioners' lawyers as theatricals, in describing us as persons who intend to be intransigent and disobedient to the orders of the court. I am sure that Frank Davis knows, Mr. Frank Davis knows, that all the applications that we have brought are within the framework of the law.
The court after recess did announce that it reserves the right to dismiss the petition should its orders not be complied with, as it gave some further directives as to how the case should proceed.
Petitioner is again directed to file his witness statement on the matters raised in his petition and other pleadings, and his response to the preliminary objections by close of the day on Wednesday, the 27th of January 2021, failing which this court will proceed to invoke the sanctions imposed on this court by the rules of court. The petition is thus adjourned to Thursday, the 28th of January 2021 for hearing.
So hearing of the case continues on January 28th, and there are a number of outstanding issues that needs to be dealt with. The first is a request that the court reviews its decision related to the interrogatories ruling. There is also the debate about the court dealing with the interrogatories request as soon as possible, among other matters that are all of importance to the petitioner and the respondents in this particular matter. Reporting for JoyNews from the Supreme Court, my name is Joseph Akable.